Okay, I think we will start. Hello, everyone. My name is Damian Honey. I'm a partner at HFW and head of International Arbitration. May I, on behalf of LIDW and behalf of the panel, who you can see before you, welcome you to this LIDW session. I'm now just going to quickly share my screen. So in this next hour, what we're going to be talking about and considering is the interesting topic of, is the evolution of institutional arbitration rules at the expense of party autonomy? We've got a great team assembled, and Ania Farren, who's a partner at Omnia Strategy and chair of the ICC UK Committee for Arbitration and ADR, and I'm sure well known to you all, will shortly introduce the team. But before that, can I just, on behalf of LIDW, thank our very generous sponsors, whose names are set out on the slide on your screen in front of you. The virtual LDIA LIDW this year certainly wouldn't have been possible without their support. So I hope you've had a chance today to go to the many sessions which have been hosted by LIDW. Perhaps I can just mention one in particular, which is essentially that of the keynote addresser, Sir Geoffrey Voss, who said, COVID has allowed us to see how much we used to deal with the on paper and equally be dealt with offline. I'm sure we'll all agree with that statement, but is everything being dealt with online exactly what the parties want, or indeed what the arbitration tribunals want? That's an interesting point, and we're going to come to that later. But for now, I'm going to hand over to Ania.
Damian, thank you so much, and a big thank you, of course, to you at HFW, and of course James and his team at Quadrant Chambers for hosting this event. And thank you, Noradéle, for joining us. Noradéle is joining us from Lalive to give us the civil law perspective. We have 4 topics that we want to cover today. I'm sure that there are others, but we have an hour, so we're going to cover 4 key topics. The first is to do with the appointment of arbitrators. The second is consolidation and joinder. The third, we're going to talk a little bit about procedural timetable and hearing venue and format. And lastly, we're going to finish off with disclosure of funding arrangements. So I should mention that we are going to be taking comments and thoughts on these topics throughout. So if you do have any thoughts, please could you add them to the Q&A box, and I will read them out during the discussion. And I should also mention that this session is being recorded. So if you don't want your name read out, put the comments in anonymously. Otherwise, I may refer to you by name. And I've just had a note from Noradéle to say she's not only going to be covering the civil law perspective. Quite right, Noradéle. Of course, we don't expect you to only contribute the civil law perspective, but hopefully you can help us on the civil law perspective, because I think that the three of us will be focusing on the common law perspective. So thank you for that reminder. So we're going to start with appointment of arbitrators, and James has helpfully prepared some slides so that he's going to set out the key rules, the new rules in the new ICC and LCIA rules on this topic in order to frame it for us before we start the discussion. So over to you, James.
Thanks, Ania. I'm sorry for sharing screen too early. Before I come to the first of our topics, a quick reminder of the new rules applied by the LCIA and ICC. I've put the details on this slide, accompanied by some whinging about the state of the LCIA's PDF that I'll leave you to read. Turning to our topic for today, Professor George A. Berman of Columbia Law School has likened international arbitration to a separatist political movement. And like any separatist movement, he says, it must lay claim to legitimacy, and it is party autonomy that largely performs this legitimating function. Professor Berman points out that international arbitration finds in party autonomy the source of its attractiveness as compared to litigation in national court. The most obvious example, he says, is the freedom of parties to select their own judges, rather than appear before judges whom the state assigns to them, and to do so in consideration of their self-interest. And that brings me more or less neatly to the first set of rules for discussion. The ICC has made 3 changes which touch on the identity of the arbitrator. Taking the easiest of the 3 first, Article 13.6 prohibits the appointment of an arbitrator in treaty arbitration who has the same nationality of any party, unless the parties agree otherwise. To that extent, at least, party autonomy is preserved. Article 17.1 introduces a requirement that parties inform the Secretariat, the Tribunal, and the other parties of any changes in representation. If those changes give rise to a conflict of interest with a member of a constituted tribunal, then the tribunal can take any measure necessary to avoid the conflict, including exclusion of the new party representatives. Finally, and perhaps most controversially, Article 12.9 empowers the ICC court, quote, in exceptional circumstances, unquote, to overrule the parties' agreement as to how the tribunal is to be appointed and make its own appointment, quote, to avoid a significant risk of unequal treatment and unfairness that may affect the validity of the award, unquote. A likely motivation for this new rule is criticism increasingly leveled at investor-state arbitration and the repeat player appointment of arbitrators with known positions on important issues. So is this an example of the community putting its house in order?
Thank you, James. So you've posed the question, and so I'll put that question first to Damian. Damian, your thoughts?
Thank you, James. It's a really interesting question, and I'm going to look at it from the question of commercial arbitration, and particularly the rule change that you've identified in Article 12.9, which essentially, in exceptional circumstances, and that's the key phrase, will allow the ICC court to appoint the entire tribunal. And I think of an example in a commercial contract where you have 2 parties who heavily negotiate an agreement, and their equal bargaining power between them. And for whatever reason that might be, the arbitration clause allows for a 3-person appointment, but the first 2 arbitrators are chosen by one party, and then those 2 chosen arbitrators appoint the chair. Now, that of course means that one party is not appointing an arbitrator. Is that going to be exceptional circumstances within the meaning of this new clause? Because if it is, then that is certainly going to override party autonomy, because that is what the parties have chosen to do. And they may have deliberately chosen that because the party who doesn't have the chance to appoint may have got a benefit in another part of the contract when they were negotiating it. And so I do think, whilst of course it does say exceptional circumstances, there is a risk, I think, that people will read that clause and think, whilst we understand there is a need for the arbitration community to get their house in order, particularly in investor-state arbitration, it perhaps may have gone a little bit too far in relation to how it impacts commercial arbitration.
Damian, that's interesting. Of course, the rule also adds that sort of the use of this power should be where there's a risk of unequal treatment and unfairness that may affect the validity of the award. So it does seem to me to be more limited than you suggest in your comments. What do you think about that?
I do accept that actually, if you look at the clause itself and you go and follow it through, you can see, well, actually it's avoiding that risk you've identified. But I think it's perhaps indicating a state of mind sometimes, and this is certainly some of the comments that I've been receiving from commercial parties who are starting to look at the rules and have seen commentary around the rules and are making choices. Of course, they can make a choice between which institutional rules they can include in their arbitration agreement. that they feel perhaps that oversight, given some uncertainty as to how it's going to be applied, is something that they're not willing to risk.
Any thoughts on that, Noradéle?
Yes, I think this rule, among the ones we're going to talk about today, is probably one of the ones that most squarely erodes party autonomy, for the reason, that Damian mentioned earlier, which is that it allows a tribunal to override even what the parties have actually agreed. And for me, that's squarely an erosion of party autonomy, in the sense that the parties are not actually able to regulate the procedure in line with their expectations and agreement. I think the point you raise, Ania, about the equal treatment is an important one, because this debate of party autonomy, I think, is partly a question of balancing what are the principles that a party is expected or can expect in an arbitration. So party autonomy is one, but I think most will agree, even clients, that of course equal treatment of the parties is another. And if they're told that their right or their autonomy is going to be derogated, but only in view of that principle, then that may be less problematic. One issue that has been raised about this rule, and I don't know if it's been tested yet because it's quite early, is the question of enforcement, and whether an appointment that overrides the parties' agreement is actually going to be problematic at the enforcement stage, given the New York Convention provisions about the appointment being in line with the parties' agreement. And I don't know if that's something that you'd like us to talk about, or if James or Damian have thoughts on that.
Well, I mean, absolutely. Should I pass over to you, James? I see you're ready to step in on that point.
Well, I have a thought, which is that it is a potential tension, certainly, and one would be left to argue at the enforcement stage, if the point were taken, that by signing up to ICC rules, one had signed up that was part of the agreement, that the Secretariat could step in and appoint someone different. So that's one thought. But another thought that I have is the extent to which this duplicates a power which already exists in the court to remove an arbitrator on the ground of bias. But that's it's a different power. It's not a straight duplication. My feeling is that this is a reaction to the noises off regarding, in particular, investor-state arbitration. And I kind of agree with Damian's point that the one brush is being used to tar the whole of commercial arbitration, when really it affects a relatively discrete, although important, part of it.
Thank you, James. I mean, so I think what I've heard so far is obviously that party autonomy is extremely important, but perhaps isn't everything. And there are sort of competing considerations of equality and also validity and enforcement of the award. And I'm also interested to hear from our audience. I haven't had any comments yet in the Q&A, but what are your thoughts on these particular provisions? And while you're busy typing them in, I thought was interesting when I read the 2021 Queen Mary and White and Case survey that the ICC is still by far the most preferred institution, 57% of users, and LCIA 39% of users. Also, thinking that these sort of latest revisions are unlikely to change that very strong preference for those institutional rules by users. Any thoughts on that from our panel?
It's all down to the quality of the PDF.
Fair enough. No, we haven't got any questions. Here we go. We've got a comment from Jonathan Wood. How often do sovereigns default anyway? So is enforcement a real issue? And that relates, I think, directly to the investor state world. Thank you, Jonathan. And please remember to post your comments next time in the Q&A function so that I can see them. Okay, any further thoughts on appointment of arbitrators?
I mean, Ania, one of the points I was going to make is, of
Yes.
course, parties can choose which rules, which institutional rules they want to apply to their contracts. So there is party autonomy in having that choice right at the outset.
Exactly.
So there is that comparative analysis to be done between the various institutional rules by parties to work to understand and to work out what they might prefer. And just picking up the enforcement point, sort of arguing against myself, of course, there is an issue that you will, as a claimant, you will always want an enforceable award. And so if you have an arbitration clause which you think might give unequal treatment, and there's a risk that that might be an argument run against you in the country where you're trying to enforce, then clearly you're going to want to ensure that actually whatever the ICC court decides to do may actually be to your benefit. So you certainly can look at it the other way around as well.
I would perhaps just add that it's also not unprecedented as a rule. Even in the ICC context, there are provisions in the expedited procedure rules where the ICC court has always been, or for a long time, been able to appoint the arbitrator as a sole arbitrator, even if that's not what the parties' agreement provides. And perhaps just to look outside of these rules and under the SEAC rules, where there is a similar provision that has been in place for a bit longer, there it has even been deemed to be enforceable where that provision was incorporated after the parties had agreed to those rules. So it raises an interesting question to Damian's point as to, whether the parties entering into that provision means they sign up to that. What if they did so before this rule was integrated?
I mean, I don't know whether you all agree or disagree, but certainly from what I've seen of what the ICC court, they are very keen to adhere to agreement of the parties, and it would surprise me hugely if they were to kind of take a broad interpretation of exceptional circumstances in this particular case. But I don't know whether any of you disagree with my view of that. I see some nodding. Okay, fantastic. So let's move on to our second topic on consolidation and joinder. And James, I know you're going to introduce the relevant rules for us again.
Thank you, Ania. So in its 2020 rules, the LCIA has made it possible to commence more than one arbitration in a single request. Each arbitration will then proceed separately unless determined otherwise by the court or the tribunal. But we're more interested with the opposite effect of joinder and consolidation of separate references. Now, as for consolidation, the ICC has relaxed its old requirement that unless the parties agreed to consolidation, the claims in the arbitrations had to arise under the same arbitration agreement. It has extended that to situations where the arbitrations are between the same parties, the disputes arise in connection with the same legal relationship, and the court finds the arbitration agreements to be compatible. The LCIA's position is now similar, but goes further to encompass a series of related transactions, provided that either the tribunals are the same or no tribunal has yet been formed. Now, as for joinder, the change introduced by Article 7.5 of the ICC rules is to allow the tribunal, once constituted, to order joinder, despite one of the existing parties objecting. The additional party must still consent to joinder, consent which must extend to the constitution of the tribunal and the terms of reference where applicable. And this is in addition to the court's existing power. The position is now similar under the LCIA rules. Again, the third party and at least one existing party, who will be the applicant, must consent. So that's a summary of the changes. And to an extent, one sees both the institutions edging towards the much more flexible provision in the LMAA terms, which allow, have a much more relaxed, not concurrency or joinder regime, but one which allows for concurrency of hearings. Anyway, I'll stop there and I'll hand back to you, Ania.
Thank you, James. So here perhaps there's a competing consideration of efficiency of proceedings, but for her thoughts, I'm going to pass over to Noradéle.
Thanks, Ania. There are definitely pros and cons to this one, and I'd be interested to hear the other panelists and the audience's thoughts on, what are the possible competing principles at play here. But just pausing on party autonomy for a moment, my thoughts on this one, especially the consolidation changes, are the following. If we think of autonomy as the right of the parties to self-govern, then clearly the question of autonomy can only arise where the parties agree. Once the parties no longer agree on how to govern the arbitration, then in my submission, it's no longer a question of party autonomy, but it's now a question of which party's position prevails over the other. Now, why is that important here? Because I think in the context of the changes to the consolidation provisions, neither of the rules really contemplate changes that go against both or all parties' agreement, unlike the one we were talking about before with the arbitrator appointment. Here we're talking about a scenario where one of the parties is proposing something and the other party doesn't agree. So I think the first answer to this is, in terms of what does it do for party autonomy, I think probably in the context of consolidation, doesn't really do much in terms of erosion of party autonomy. A bit different for joinder, because I think there is a scenario contemplated under the LCIO rules where the tribunal can do it on its own initiative. But certainly for the consolidation one, I think the principles or issues that arise from these changes are different. What it does affect, and this links to our previous topic, is the right to appoint an arbitrator. And I think that's where the autonomy of the party can come in on this one. Because of course, if you're consolidating an arbitration, you're bringing in parties to an arbitration who have not selected those tribunal members, then what you are eroding in terms of party autonomy is their right to appoint an arbitrator. So in a way, it brings us back to where we started on topic one. But I think beyond that, I don't see any additional erosion from party autonomy. Now, of course, as you said, there are other, disadvantages and potential advantages. You mentioned efficiency that arise from those changes. I think that would be interesting to hear about the others from.
Noradéle, that was, I think, a very interesting and important distinction to make between these provisions and those we've just discussed. Damian, any thoughts on what Noradéle has just said?
I think, just picking up what Noradéle said around efficiency, and I think the key point here is there's been quite a degree of criticism of arbitration for just narrowly determining one contract dispute when, and I'll give an example where in my particular field where I do quite a bit of work, which is energy commodities trading, where you can have daisy chain contracts where A sells to B, sells to C, sells to D, sells to E, and they're literally flipping them back to back. And so you have they're entirely separate contracts, but the facts are entirely the same and the legal issues are entirely the same. And it's efficient to have all of those matters, all of those disputes determined together. And so what you're finding, I think, and certainly this is something I would encourage, is that the arbitral institutions are realizing that there is efficiency in the process, which also avoids irreconcilable awards as well on the facts if you have an entirely separate tribunals determining the same facts. And that's the process through which the arbitral institutions are actually saying, well, this is an efficient process, but also it's a fair process as well to allow it. So ultimately, yes, as Noradéle has identified, there is party autonomy at risk here, but I think the greater good is the efficiency of the process for all involved.
Thank you, Damian. Yes, important to mention, the avoidance of irreconcilable awards. I think that is an important competing consideration to party autonomy. James, any further thoughts on this topic?
Well, yes, and I think the party that's going to decry the erosion of its autonomy in this sort of situation, particularly in the back-to-back contracts that Damian has been describing, is the one who's going to be picking up the tab at the end of the day. And by making it more straightforward and streamlined, to have the whole thing determined, as it were, in one go, one is simultaneously removing what can be a potentially strong bargaining chip in settlement. You guys, go ahead and sue each other for the next 5 years, and I'll take my risk on a favourable award somewhere in the middle, which will see me right, and while you spend a multiple of the amount at stake. So that's never a very attractive bargaining position, but it is one that one encounters in practice regularly, and one can understand individuals on occasion being disappointed that that particular strategy is not as available as once it was. But that said, of course, what is critical with consolidation and joinder is timing. And if you don't get the timing right in terms of when the references are consolidated or when a new party is joined, you're not going to have a more efficient process. You'll have one that is a bit like a car with a handbrake on trying to start. It's just bouncing down the road and not really making any real progress.
Thank you, James. Yes, everyone wants their arbitration to be efficient before it starts, but of course, one party may not be in favour of efficiency once they're started. So that's an important point to raise. Okay, so does anyone want to add anything on this topic? And if I see that no one has added questions or comments to the Q&A, I please encourage you to add comments on this topic. In the meantime, any further comments? If not, we'll move on.
I'm happy to comment, Ania, while people gather their thoughts on the Q&A. With just in terms of maybe giving some examples of legitimate reasons why people may want to avoid consolidation, because I think it's always easy to think about the sort of nightmare scenarios. But if you think, for example, in the construction context, there may be situations where there are sensitive, confidential information that you wouldn't necessarily want to share with a related party or a party with whom you have an arbitration agreement under a different but related agreement. Or equally, in a chain, when you're the contractor, you may want to first see how you go with your subcontractor before going against the employer. Whereas if you're forced to do it all at the same time, it may actually create proceedings that you wouldn't have otherwise contemplated. And that's, in a way, the sort of flip side of efficiency. Just on the flip side of efficiency, because I've had this scenario as arbitrator as well, sometimes it's not that easy to then work out how the order of submissions should go, whether it's pleadings or memorials, and who should go first at the hearing and in writing. And what happens sometimes is, because parties insist on having the last word on where they are claimant, is that actually you can have quite complex procedures with many more steps than you would have in a sort of, straightforward arbitration under one contract, even where you might have counterclaims. So that's, I think, just something to be borne in mind in terms of efficiency. And then on timing, I thought James's point was interesting, and it made me think of tactical complications, arising from this rule and people trying to avoid this rule. So one is what James mentioned, which is you wouldn't start a procedure until the other one is well underway, because I think under both sets of rules, if the tribunal is already established, then that's a factor that would weigh against consolidation or joinder, which may in turn lead to more inefficiency because you're holding back on certain claims or starting proceedings for tactical reasons rather than because rather than because they're not ripe for arbitration. And the other one is, if you think far enough ahead, is to make your arbitration clauses not compatible, because also under both sets of rules, I think if the arbitration agreements are not the same if under the ICC regime, or they're not compatible under the LCIA regime, that's also a counterweight against consolidation or joinder. So what might happen then is to parties thinking tactically ahead, making their chains of contract subject to different seats, for example, in order to make their agreements not compatible, which actually makes the transparency and coordination of proceedings even more difficult than if you didn't have these consolidation provisions, as a threat in the first place.
Thank you, Noradéle. And you have someone in the audience that thinks you're spot on. So Lucas says spot on, Noradéle. In particular, I think in relation to the point you made about how proceedings may become overly complex where they're consolidated. Okay, so we've got no further comments from the audience. So let's move on to our next topic in relation to the procedural timetable and format of the hearing. There are sort of two subtopics here, but let James first introduce the relevant rules, and then we can move on to the discussion.
Thank you, Ania. Both institutions have brought in rules that recognise what has become reality during the pandemic by expressly contemplating remote hearings. The LCIA has also introduced an early determination procedure to weed out any claim or defence that is manifestly outside its jurisdiction, inadmissible, or without merit. The ICC hasn't changed its expedited procedure, but it has increased the limit on the claim value in respect of which it may be invoked.
Thank you, James. Okay, so if we just start off talking about procedural timetable, just ask my panelists, are parties happy to have their right to be heard curtailed by the arbitral tribunal in the pursuit of a more efficient hearing? And here in particular, I'm thinking of, the situation where both parties have agreed to a particular procedural timetable and have presented it to the tribunal. Should the tribunal simply accept the parties' agreement, or if they think that the procedural timetable is perhaps simply too long or in some way inefficient, are they within their rights to go back to the parties and say, no, actually, we're going to make some adjustments to the timetable? That obviously isn't linked directly to the new rules, which we'll move on to shortly, but I thought I'd get your thoughts on that particular aspect of party autonomy. Damian, do you have any thoughts?
Yeah, Ania, I mean, it's a very good question, and it depends, I suspect, on which side of the fence you're sitting on a particular arbitration, whether you're counsel or whether you're the arbitrator, and it depends as well which seat you're in, because seats will have rules around the obligations of the tribunal. My view is that the parties have chosen arbitration. The parties have chosen particular rules, which has allowed a tribunal to be appointed. They are therefore comfortable with that choice. And if they present a timetable to the tribunal and the tribunal says, well, actually, we would like to ask you about this, or we don't quite agree with that, then that's very much something I think that the tribunal should be doing to benefit and to question the parties as to what they are proposing. And that then can be a discussion, and the tribunal then has to form a view. But I don't think a tribunal which has been appointed should be bounced by the parties into a timetable which to the tribunal, having looked at the matter, they might think needs to have further investigation.
Any thoughts on that particular point from Noradéle or James? No? Or do we want to move on to thoughts on the new rules on early determination and expedited proceedings? Because of course those also relate to the efficiency of the proceedings and the timetable, as it were. James.
Well, I think Noradéle was putting her hand up, but
oh, sorry, I missed that, Noradéle. I was waiting for you to unmute yourself if you wanted to make a comment.
I mean, I think fundamentally there are always going to be limits to the extent to which even the most autonomous parties can bind their tribunal, and they can't require them to sit on days when they're otherwise engaged, for a start. What I'm finding as arbitrator increasingly is that whilst you get some parties which are very well represented by very experienced lawyers, that's not necessarily the case every time. And actually the parties need guidance from the tribunal as to what is feasible, what is necessary. Otherwise, the timetable becomes unrealistic, or in either direction, either taking far too long or having far too many components to it, or topics of expert evidence which are completely inappropriate and unnecessary, or something which is much too short, or misses out key steps which you can see from the nature of the issues are going to be required, like, for example, supplemental witness statements and so on. Turning to your questions, Ania, sorry, expedited procedure, I think that's going to be quite interesting. I may or may not have a reference at the moment in which that may or may not become a real live issue, and it'll be very interesting to see how that works if it does, particularly as I'm sitting with a couple of very experienced arbitrators, one of whom is a former judge, that new option in the LCIA rules is going to be very interesting to see what teeth it has in practice. I can't say more at the moment, but I think anything which can seriously short circuit an obviously unmeritorious case is probably a good thing. But it would be difficult to say that the parties had signed up to that, because at the time they entered into their contract, these rules were still a twinkle in the LCIA's eyes.
That's true, James. Noradéle, any thoughts?
I was just going to say, from an arbitrator perspective, two things. One, to echo what Damian said earlier about the importance, if you are going to try and override what the parties have autonomously agreed, is communication with them and seeking their contributions, on the points you've raised. The difficulty with that, of course, is that usually, proposing an alternative to the procedural structure may favor one party over the other, and that needs to be approached quite carefully. And the other thing is, I think it's quite important to communicate, if there is an institution, to communicate with the institution about doing that, because some institutions are more sensitive than others in terms of, arbitrators adapting the procedure in a way that is different from what the parties have agreed. And I think that's quite important to bear in mind.
Thank you, Noradéle. Good points. So I'll continue to take comments on that in the Q&A box, but I'm going to move on to our second subtopic, as it were, the one of virtual hearings, because of course it's so relevant for all of us at the moment. And again, sorry to go back to the Queen Mary study, but in that it was interesting to see that 79% of respondents said that they would rather proceed with a scheduled hearing virtually than to postpone, and 87% of arbitrators also favoured proceeding with a scheduled hearing virtually. So, Damian, thoughts on the provisions that relate to virtual hearings?
Well, I think the provisions which relate to virtual hearings obviously bring the rules bang up to date, because it's reflecting reality. And I think for anyone who's been involved in a virtual hearing knows how well they work and how well the efficiencies are driven, both with regard to electronic documentation, but also with regard to less travel, less need to book rooms, and less need to book hotel rooms. And equally, it makes it easier for witnesses to be called. They can't say they can't travel. They can now obviously have to say they haven't got a Wi-Fi connection, which is tricky. But I do think there's going to have to be a period of reflection, because I certainly think there will be cases, there will be matters where the ability of the tribunal to look and see the demeanour of the individual witness when questions are being asked, and equally that of expert evidence as well, but particularly factual evidence in a heavily contested factual case. I do think that the tribunals and equally the institutions need to be a little bit careful about laying down rules which too rigidly push someone down a virtual hearing route, because of course that's where we're at the moment. But hopefully soon in the not too distant future, we will be through the pandemic, and there will be an ability to hold actual hearings. But I do think a party must have the right, either party, to if they want a live hearing, to have a live hearing, but obviously have to be able to put forward good reasons and good and cogent reasons for it. Because yes, efficiencies are driven, but equally, we all know that email traffic has sort of certainly risen exponentially as a consequence of all of us being online, and that generates, that's a generator of pollution, because the amount of things we send. So you're offsetting one with the other a little bit, but it's up for debate, I think.
So are the rules really pushing us down the virtual arbitration path? I mean, they do still, I think, require arbitrators to consult with the parties and consider all relevant facts. Any other views on that from James or Noradéle?
There may be a strong temptation by arbitrators, on arbitrators, particularly now we've got used to the tech and used to a virtual hearing and used to not having to travel and live in a hotel room and so on, to opt for a virtual hearing, really for not much more than personal convenience. And I think that would be an unfortunate message for the arbitrator community to be sending out to the end users, because we are, after all, just all components in a service industry, servicing and serving commercial needs. That said, my experience during the pandemic has been that the parties that shout loudest about wanting an in-person hearing are those with the most hopeless case, who are trying to push off the evil day for as long as they possibly can. And although they are allowed to make their application and advance their reasons, and there can be many and various, so far they have all been unpickable, and they haven't got anywhere. And there's, I think, underlying all this is that if parties want to try and throw spanners in the works, arbitrators are going to have to be ready to catch them and throw them back again if that's what has to happen. But I completely agree with Damian that one needs to be cautious moving forward. I mean, the pandemic, in effect, took a situation which already existed, which was that video link witness evidence was becoming more and more common, and has basically thrown it down the stairs, and so that everything has gone online. And having dipped our toes in that water, actually, it's not been as bad as some predicted. And once people have done basic things like plug into their broadband routers rather than try and do everything on Wi-Fi. So, it's so far so good. And I think the rules strike a fair balance in between the legitimate interests of parties and the general interests of efficiency and getting to as right as possible a result in as sensible a time frame as can be done.
Thank you, James. And of course, you mentioned, convenience for the arbitrators, but presumably many arbitrators will also be concerned about the difficulty of rescheduling many of their hearings, and of course, thus resulting in even more extensive delays than the parties may envision. Noradéle, any thoughts on that or anything else relating to virtual hearings?
Yes, I think that the rescheduling of the hearing and also the rendering of the award, because a lot of arbitrators, especially when you have a panel of 3, will have planned in advance when is the time that they're going to be working on the award. And I think this is something that parties will have to contend with if they're asking for a physical hearing, as the postponement of the hearing, but then also the loss of that window of the rendering of the award. So I think those are certainly important considerations for parties to bear in mind. And I was just going to throw in that for this debate, I think it would be interesting to also consider hybrid hearings, because previously when you had in-person hearings and a witness couldn't appear, unless they had very good reasons to come by video, it was largely frowned upon. And I think something that parties and counsel and the arbitrators can probably be a bit more flexible about going forward is if where parties don't agree one way or the other on virtual or physical, is the possibility of saying, well, okay, we'll do it physical for the council and the tribunal, for example, but to have a level playing field, all the witnesses will be virtual, for example, or certain witnesses or experts. And I think, you know, having the flexibility of you know, not seeing it as black or white. And now that we have that experience of not only virtual, but also hybrid hearings as a way of striking a balance of both efficiency, but also making sure everyone is still proceeding on an equal footing.
Thank you, Noradéle. Yes, important to mention hybrid hearings. So we have got two comments in the Q&A. First, actually, is a question from Colin. Does the panel think witness credibility is as effectively assessed via Zoom as in person? Who wants to tackle that one? James.
Yeah, this very question came up during the lunchtime session on the main stage of LIDW. And Dame Elizabeth Gloucester's response was that she hadn't found any difficulty at all in assessing witness credibility, just as well by Zoom. And indeed, in some respects, she found it easier because one had the witness's face much closer up than would be the case in a conventional hearing room. And she also made the point, which is an important one, that actually assessing witness credibility by reference to things like body language and tone of voice and all the usual markers that we use is actually highly disputable as a really efficient way of telling whether a witness is telling the truth or not.
Thank you, James. And a useful comment also from our audience. Is there a risk of being too focused on the efficiency of the process and not softer aspects, such as the benefit for key decision makers from the parties being in the same room and having an opportunity to speak during the hearings? And I'm sure that is the perspective of many parties or our clients when we tell them that their hearing might take place virtually, who want to have their day in court, as it were. Damian, you're nodding. Did you want to add?
I absolutely agree with that comment. It's something that I'm concerned about. Sometimes I think with the setting of all these rules, sometimes the institutions lose the idea that actually, I certainly feel as counsel that I've failed if the parties end up at a hearing, because that's the last thing that you want. You want to try and see if the arbitration process can resolve it before you get to a hearing, and it allows a party to have an argument, but ultimately find a solution. And yes, hearings are great for that. And actually, maybe the first time the parties have seen each other for a long time. So I would agree with that comment, absolutely, that there are significant advantages to that.
Thank you, Damian. And I see we have another comment from Jonathan Webb, which I'm just going to read out. Agree with the thrust of the panelists' points about finding a new balance between cost efficiency and convenience of the parties and arbitrators on the one hand and efficiency of the process on the other hand. Surprised, however, to hear that no one is mentioning sustainability issues as the major driver for more remote hearings. Truly, surely, it's absolutely crucial. So sustainability, of course, as a countervening factor to party autonomy. Anyone want to add anything on that particular point?
Noradéle does.
I mean, I think Damian alluded to it earlier, right, when he was talking about pollution, caused through other means. Certainly, as an arbitration community, I think that's something that's very much on our radar, to be seen whether the corporates and users agree that should prevail. If they've got a sort of bet the company arbitration, whether that would be for their one-off case or their big case, the prevailing consideration, to be seen. Ania, I've also seen there's a comment or question in the chat function. I don't know if you want us to have a look at that.
It's in the Q&A as well. You're muted, Anna.
Is that the one from James Clancy? Yes, so about to read that one out. Thank you, Noradéle, for prompting me. This is a good point, James. To avoid delays but promote the possibility of hybrid and even in-person hearings, will there be a temptation to have a tribunal appointed, all of whose members are located in the same city? Noradéle, did you have thoughts on that?
Yeah, I had it's an important point, you know, where the parties will sort of make tactical elections like that. I would just say that there is a flip side to that coin, which is I have a case currently pending as counsel where our arbitrator members are so distributed across the world that actually I don't see how we could have a virtual hearing in that scenario, because it would require one or two members of the tribunal to have 3 weeks of hearing in the middle of the night. And so actually it can be a counter consideration that if you have them flung apart, you're maybe more likely to have an in-person hearing, because it's the only way that it would really be sustainable over a long period of time.
Yeah, exactly, the time zone issue. I see we've only got a few minutes left, so let's move on to funding. James, will you do the honours of introducing the relevant rules?
So this new provision in the ICC rules appears in an article concerned with arbitrator impartiality. It's expressed to be designed to assist arbitrators and prospective arbitrators to comply with their duties of impartiality. It requires parties to inform the Secretariat, Tribunal and other parties of the existence and identity of any non-party, quote, which has entered into an arrangement for the funding of claims or defences and under which it has an economic interest in the outcome of the arbitration, unquote. On its face, that would not just cover commercial litigation funders, but would extend to subrogated insurers and beyond. Is this a good thing?
Thank you, James, for introducing the funding topic. And of course, because I have spent some time at a funder, I will start the ball rolling. You've already explained what the rationale is for the new rules, and of course, the reason why these were introduced were not necessarily they were not institution led. They were as a response to what we've discussed before, the growing demand by users for a greater transparency in international arbitration. And of course, as you've already mentioned, the rationale is to help kind of prospective arbitrators in their disclosure duties to avoid any possible conflicts, which is important in turn to ensure the enforceability of the award, something that, again, we've already discussed in relation to some of the other rules. So, from the funder perspective, if I could just start with that, from my experience, funders are very much in favour of these provisions because it protects the enforceability of awards, and thus it protects the value of their investments, of course. I would suggest that while funded claimants may often be wary of the duty of disclosure, it should also be in the interests of funded claimants, because as we see more and more disclosures being made, in my view, funding will become more and more the norm, and thus we will see less of the sort of knee-jerk reaction from opposing parties and perhaps tribunal members when they learn that a party is funded, because of course parties may seek funding for various reasons and not necessarily because they are impecunious. There are many other very good reasons for seeking litigation funding for your claim. So those are just some initial thoughts. And I see Damian has unmuted himself. Do you have any other views or any further views on that?
It's just, I suppose, Ania, this distinction with some of the institutions as to their approach, and particularly the HKIAC rule, which obviously you have the ICC rules, which ask for the existence and identity of any non-party which has entered into the funding arrangement. But the HKIAC rules go slightly further, and certainly I think it's Article 44 require the disclosure of any funding agreement. Now, certainly as I see it, I can certainly understand the very reason for the disclosure of the identity of a third party as so described in the ICC's rules. but I wonder whether, from the funder's perspective, it is the disclosure of the agreement, which is obviously a private agreement between two parties, taking a step too far?
Yeah, I think, Damian, I would absolutely agree with you that one can see why you would want the disclosure of the fact of finding and the identity of the funder. But I think the view is very different in relation to, revealing what the terms of the funding agreement are. Absolutely, that's an important distinction to make. James?
Yeah, Jonathan Wood has put a very pertinent question up in the Q&A, which is, so if there are 15 subrogated insurers on the policy and 3 layers of reinsurance, do they all have to disclose their interests? Well, as I read the rule, yes, they would. And I have to say, the prospective arbitrators out there looking for their first ICC appointment read this sort of thing with a sinking heart, because the chances, we've all been told by the ICC, basically, if you have to put anything in the declare an interest box, you're doomed. And the chances in some sectors that you haven't worked inadvertently, probably in complete ignorance, for a particular subrogated insurer or reinsurer is very low. And so this may actually discourage people who are specialist and knowledgeable in certain areas from, well, if not discourage them, then disable them from taking appointments, because suddenly factors which really they're probably ignorant about and certainly didn't play any particular role are suddenly going to matter. And I wonder if this is too hard a hammer to break this particular nut.
Thank you, James. Yeah. Noradéle, have you got anything to add on that?
Perhaps just to circle back on the party autonomy point, the angle I see on that is that clearly these rules, however you interpret them and who they cover, will cover certain types of funders in a broad sense and not others. So I think it's going to be, not debatable that they wouldn't cover, for example, intercompany funding arrangements in a group of companies, or a situation where a company decides to take a loan, not necessarily linked to that particular arbitration, but just generally to finance itself. And I think the fact that they would have that the companies or parties would then have to make a choice or be impacted in how they choose to be funded in running an arbitration by virtue of having to disclose certain identity of some types of funders but not others, I think has a party autonomy erosion angle to it.
And thank you, Noradéle, for circling us back to party autonomy, because it is time to wrap up. And I think I'm passing over to James for some final thoughts before we get to socialise.
Thank you, Ania. Yes, well, if party autonomy is the foundation of our separatist movement, I think our discussions have shown that it's potentially difficult to keep all parties on board equally happily all of the time. There are going to be times when parties feel justifiably that their autonomy has been eroded too far, and others where they have exactly the same feeling but unjustifiably. And in reality, it is very difficult for institutions to cater fairly for all interests at all times. For myself, I think these reforms are relatively modest and do a reasonably good job of treading the fine line. If there's one that sends shivers down my spine slightly, it's the last one that we were talking about. But that's it for now. We've put the link to the networking in the chat, but our ever-efficient Sarah Longden has also emailed everybody who's attending with a link, and I hope very much to see some of you at least on the other side. Thank you very much indeed for coming along. Please do check out the other events and the London International Dispute Week's website, and have a very good evening.